Good morning, everybody. We're going to call to order this Alarm Systems Contractors Board meeting Thursday, October the 16th, 2014. Ms. Vess, will you please call the roll?
Scott Cockroft,
Here.
Keith Harvey, Vivian Hickson,
Here.
Karen Jones,
Here.
Mackenzie Roberts. Let the record show that Keith Harvey and Mackenzie Roberts are not here. They're not present, but we do have a quorum, Madam Chair.
Okay, thank you. Have the board members had an opportunity to review the agenda for today's board meeting? And if so, a motion to adopt.
Yes, Madam Chair, I move that we adopt the motion as presented.
We
The
had
agenda, I'm sorry.
we had one change. There was just one. Do I need to make that?
No,
Oh,
No,
sorry.
agenda.
I thought we were.
This is
I'm
just the
sorry.
agenda. It's okay.
Jumping
Second.
gun.
Okay. We have a motion and a second to approve or to adopt our agenda as presented for today's board meeting. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. The next item on the agenda is a review and approval of the minutes from the September the 18th, 2014 board meeting. And I think there is a correction that Mr. Cockroft needs to bring to our attention.
I would make a motion to approve with one change. The course that I reviewed was the AMG Avalon Wireless, which shows Keith Harvey, but I reviewed that one, and my name is on the AMG Minuteman UPS. I believe he reviewed.
And this is on page 13 of the minutes for your reference.
I would make to clarify that, make a motion to approve with those
A second.
amendments.
Okay, we have a motion and a second to approve the minutes with the one change. All in favor, voice by saying aye.
Aye.
All opposed? Motion carries. Next on our agenda is the legal report by Mr. Scudder. Are you ready for us?
Yes, ma'am, I think so.
Okay.
I appreciate y'all letting me move a few cases out. I know y'all are pretty exhausted from the rulemaking hearing, but I'm trying to get as many cases moving through the pipeline as possible. If you have any questions, feel free to stop me, and I'll try to answer them as best I can. And y'all want to change the recommendation, y'all certainly aren't going to hurt my feelings, so don't worry about that.
Okay.
And I'm just going to start and keep going until y'all have questions for me. Case number 1, ending in 9021, the complaint was established when the board office received termination notices on 3 registered employees which were not filed within the 30 days of the employee's termination. This is this respondent's second offense for this type of deficiency, and the respondent also failed to respond to the board's request for a response to the complaint. The recommendation is to authorize a formal and send a consent order to the respondent DQA with a civil penalty in the amount of $400, which represents $100 times 3 late notices plus another $100 for failure to respond to a board complaint.
Okay, one thing in the past, and I think it's subject to everybody's discretion, but we normally have the rule or the TCA code or whatever that's applicable to this for each one of those. And if you want to take a second to read it into the record, we'll give you time for that.
Sure, I'll be glad to
Okay.
do that. I did that on some of them, but some of them I did not.
That's okay.
Let's see.
Laws and rules.
I'm afraid to take my iPad back to the menu because I may not get back to,
I've got a written set over here if you need them.
okay.
Please.
Actually,
Oh, the
62,
full
32,
complaint number?
311.
Okay.
I'm
even on the next one.
Okay.
Register of application.
The rule that we're making reference to here is Rule 0090-01-.06 subsection 9K.
Okay,
And that is for failure to file a termination notice. And then failure to respond to the complaint, I'm not sure that, is there a rule?
I'll give it to you in a second. There's two of them, actually. Oh 0090-01-.14. .14. Says any alarm systems contractor designated qualifying agent, or registered employee must respond to all requests by the board for additional information or for response to any complaint initiated against said alarm systems contractor, designated qualifying agent, or registered employee within 30 days of the date of the request.
those rule numbers inserted into this case number 1-2014019021. Do we have a motion to accept or reject our council's recommendation?
What's been the typical amount? Has it been $50 for a first offense, and then this is $100 because it's a second? Do we know how long I mean, do we keep track of how long ago the other offense was? I mean, are we talking years or?
Yes, our system does maintain on there when the complaint was 2013, 2012. It doesn't drop off. If that's what
I
you're
was just curious.
We don't
I mean, are
drop
we
them
talking
off
about-
after 2 years, 5 years, or whatever. No, sir. The complaint stays on to the file.
No, I mean, as far as the second recurrence, as far as was that 10 years ago or 2 years ago? Or
They keep track of it, but it's normally not presented to us.
if it's, oh, okay. Do we, it seems like that would have some bearing on it if it was.
We can ask the question, how many have they had, how big a company is it? We can ask certain questions, but it's not ever presented to
I
us.
think what
Okay, I
our
think I've got.
board member is asking is if you've committed, say, an offense, after 5 years, we don't look at it again and call this your second one?
I think he's
The time
asking was
frame.
when was the first one relative to the time of when the second one was? What is the time frame between the first one and the second one, if you kept those records?
Yes,
It
we
was
can, yeah, we do have that information because we'll do it by the complaint number. Like this one starts with 14, the one last year could have been, if it was last year, it would have been 2013.
It
Yes,
was
sir.
in
We did.
2012.
2012.
That's, I
Yeah.
think that's
Is that
what he
what
was
you're
wanting
asking?
to know.
Okay.
Yeah,
So I would make a motion to
concur.
concur with our council's recommendations.
I'll second.
Okay, we have a motion and a second to concur with our council's recommendation in this case number 1. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 2, case number 2014019031, was established when the board received a termination notice on a registered employee, which was not filed within 30 days of the employee's termination. Additionally, the respondent failed to respond to the board's request for a response to the complaint. That would be, again, Rule 0090-01-.069K for failure to file termination notice of a registered employee within 30 days. And on the failure to respond to the complaint, Beth, could you read that off to me one more time, please?
0090-01-.14.
We have a motion by the board on this matter.
Make a motion to concur with council.
Second.
Okay, we have a motion by Ms. Jones, a second by Mr. Cockcroft. I'm sorry, I drew a blank on, to concur with their council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Number 3, case number 2014-024101. The complaint was established when the board office received a company renewal form, a company renewal from the respondent DQA that failed to include a registered employee's name that was previously registered with the respondent company. The board office had not received a termination notice for this employee. In response, the respondent stated that the termination notice was mailed in a timely manner and emailed a copy of the termination notice that they claimed they mailed. They sent us a copy of a letter that they said they put in the mail with a note on it, this was mailed on X date. But we have no evidence or that it was received in the board office. And so the recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $50 to the respondent, DQA. And once again, that is in accordance with Rule 0090-01-.069K.
I make a motion, we concur with council.
Second.
Okay, we have a motion and a second to concur with our council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 4A, and I put put these complaints a little differently with subparts because they're against the same complainant, and that way that would let y'all know if you had concerns that maybe I was piling on somebody, putting too much on one person, or that a person has more than one complaint pending at the time. I'm not sure if this will be the best way to do it. I'll let y'all see if you like it or not. Case number 4A is case number 2014-014911. This complaint alleges that the respondent monitoring company, through a door-to-door salesman, employed misleading information to sell the complainant a new contract. The respondent states that the representative was not employed by them, but by one of their authorized dealers. The authorized dealer was not licensed in the state of Tennessee at the time of installation. The authorized dealers do not identify themselves clearly, and respondent monitoring company appears to be complicit by allowing the authorized dealers to make these representations, creating consumer confusion. Subsequent to the filing of the complaint, the respondent monitoring company allowed complainant to cancel her contract. The respondent monitoring company also states that the complainant's system did not work because she did not have a telephone landline. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,500. This number represents a $500 civil penalty for participating in a joint venture to provide equipment or services where all parties to the joint venture are not certified. And I'll get you the citation for that in just a second. B, subcontracting the provision of equipment or services requiring a certification to an uncertified person, firm, association, or a corporation in violation of TCA 6232-304 subsection E and F, plus another $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D.
So the complainant says that a dealer that was not licensed sold her something and signed her up with monitoring and the company monitoring station was licensed, and so they let the complainant out of the contract because the dealer didn't have a license. So it's the DQA, or so they say they're a DQA, that you're fining, and not the monitoring station.
This particular complaint is against the monitoring company.
Okay.
And what our thing that we think they did wrong was, they're, say they're ABC, for example, and I don't think that's a real monitoring company.
Yeah.
I'm just pulling, I say XYZ.
That works.
For clarity purposes.
Okay.
XYZ monitoring company is allowing this local alarm company to use their name and on their cards and that type thing.
But the local alarm company doesn't have a license.
This particular case, they did not.
It says at the time, have they since gotten licensed?
They have.
But this case is against the monitoring station
Next case
right now.
the next case is against the alarm company.
Okay,
That's the reason they're together.
so are we gonna vote on Part A and Part B separately? Okay, for A, I would recommend that we go with the recommendation of council.
Where, and this is a repeat offense? I mean, this is a,
They're connected somehow, because he said he was gonna do them like
I understand
A
the
and-
connection between the two, but this particular monitoring company has had complaints before of this same thing, or? Next part is, I mean, where do we come up with this amount? Is that based on it being a repeat offense, or?
Well, it can be up to 5,000 for the first offense on anybody, whether it's their first or 31st.
And some of what it says in it's the law, right? Or it's, and some, it has some amounts in there, but those are strictly if it comes to, if they don't agree to the consent
There's some
order.
guidelines that we follow normally, and I'll find them here in a minute. Let's see, rules.
We have, they have complaints, previous complaints, but I'm not sure that it's necessarily for this exact same thing. And they also have some complaints that we'll get to a little later on in the legal report.
And I really meant specifically about this, that
Could be, and it could not be. I don't want to.
I think,
somewhere it references an amount in there, and we've kind of done different than what the statute says, but I think that's because that's based on if they go to a hearing. I just never seen that. Does that,
Is that on the iPad? The
No.
fee payment schedule?
I looked and couldn't
I
find
need to
it.
put it on there. Let me see. Hold on.
that's where a lot of my questions go back to, 'cause I've never seen where we came up with those. And I know
It's
there's
just a
some.
guideline that we
some
have
guidelines.
followed
Guidelines.
for
On
years.
it, on the schedule.
My concern with this one would be if they're really allowing them to do it or not. I know we've heard some others before that it was a repeat offender, and council felt like it was blatant and they were allowing it to happen. Because I know that a monitoring company could have a dealer program and they could have someone out there using their name without their, consent. But if they're buying the agreement from them, I guess that's pretty much saying they're allowing it to go on, and they.
I think this is similar to one that I presented at the last meeting.
Does anybody want to see
Um,
this?
That's why I was wondering if it was, related or the same sort of thing.
There's your payment pay schedule.
Oh, okay.
Payment pay. I can't talk.
That's one of them. Then company.
I was just wondering where we're basing the 2,500 on them.
That's where they pull it from.
I don't think joint
the first
venture
one.
is on
It
there.
would be joint venture is what it would be,
Yeah,
wouldn't it?
but I don't,
I don't think we've got
That's
a
not on
standard
there?
one for joint
Okay.
venturing. But I'll leave this document up.
I feel
Y'all
like the
need to
blame
look at it
falls more
again.
with the dealer than the monitoring company personally.
well, I haven't looked at this case specifically, but it does sound from what he described, sounds like the same explanation that we've gotten, and it's almost like a form letter that they send us saying, well, yeah, they're an authorized dealer for us, but we're not complicit in allowing this, but at the same time, after they've been put on notice, it seems like
Stopped it.
they haven't really done anything to correct the
That's
practice.
because the dealer keeps sending them revenue contracts.
Was the dealer licensed at one time and it was expired, or they just got licensed? They had never been licensed until after this happened.
They got their license after this happened.
So it's not like the monitoring company could have verified their license, they had a license, and then at this point in time, they're,
Well, they could have verified if they had one, if they got it on the net or else called us.
right, but I meant
The
from the,
town-
It was unlicensed activity, not expired licensed activity, but unlicensed activity.
I was just going towards if they could have years ago verified they had a
Blatant
license,
disrespect
then that had
of the law.
lapsed or something, the monitoring company wouldn't have necessarily known if they don't go through a process to check it regularly, which I don't think a lot do.
They do it more now than they used to.
Okay.
Some of them are, they won't even let them have any funds released if they can't
License.
verify their license, so.
Makes sense.
Okay, we have a motion by Ms. Jones to concur with her council's recommendation. Do we have a second? I'll make a second. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed.
The motion carries. Now we're ready for 4B.
Case number 20140-14912 arises from the same set of facts that I just told you about in 4A. But this is against the door-to-door salesman installer. The complaint alleges that the authorized dealer by and through a door-to-door salesman employed misleading information to sell complainant a new contract. This company was not licensed in the state of Tennessee at the time of installation. The salesman did not identify his company affiliation clearly, and the monitoring company has allowed its authorized dealers to make these representations, creating consumer confusion. Subsequent to the filing of the complainant was allowed to cancel her contract. And the respondent also states that the complainant's system did not work because she did not have a telephone landline. But the respondent installer has subsequently become licensed in the state of Tennessee. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,500, which represents a civil penalty of $500 for engaging in the business of an alarm systems contractor without certification in violation of TCA 6232-304A, plus another $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319, subsection D.
Make a motion to concur with council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second? I'll second the motion. All in favor, voice by saying aye.
Aye.
All opposed?
Opposed.
Okay, motion carries. Number 5?
Case number 2014-01-5591 alleges that the respondent employed improper door-to-door sales tactics and had unregistered alarm employees selling and installing alarm systems. In essence, the complaint alleges that the salesman walked up and stated, "We are here to upgrade your system, your existing service," but in fact canceled their existing service and changed it over to the respondent. However, a thorough investigation revealed that that after the contract was signed and before the equipment was installed, the respondent telephoned the consumer, went over the terms of the contract, and assured the consumer that they were not affiliated with their previous alarm provider. These telephone conversations were recorded and provided to the investigator. Of the consumers identified as victims of this alleged tactic, only one would provide a sworn statement to the investigator. They indicated that the statements submitted with the complaint had actually been written by someone else and they just signed them. All respondent salesmen operating in the state of Tennessee appear to be properly licensed. The recommendation is closed for lack of probable cause for discipline, as this appears to be a contract dispute best resolved in civil court.
Make a motion to concur with counsel.
I feel that there were some deceptive practices or something. Is there not something already? I realize that's what all the earlier rules would.
That's what the
Go
last one
towards.
was about, deceptive, fraudulent, and dishonest.
In this one, they provided the investigator with a zip drive where their
Who's they?
the respondent
Respondent.
provided the investigator with a zip drive where the respondent had phone. I can't remember the exact terminology they used, but phone people that called the consumer and went over the contract with them and said, this is, the terms, we're not affiliated with your old company, and the
So
consumer.
that's who provided the recording. I thought you were saying it was the other way around, that the recording was provided by the consumer, but.
No, in the respondent, our investigator, talked to the respondent, and the respondent said, well, we record these conversations, and here's a recording, and sent us a thumb drive with the telephone conversations where their representatives went over the contract with the consumers.
The salesman may have made but then this was probably a follow-up call by the company then.
I think they called them welcome calls or something like that.
So, because the complainant is saying someone else wrote the statement for them, we really don't know who this person was that,
Well, I think there was one consumer who was irritated by the sales tactic, and so he kind of got his neighbors to sign complaints, but the actual drafting of it was done by him. And
so
then
did
they
he pursue it or did he drop out too?
I don't know the status of that, but our investigators contacted these consumers and asked them to sign written statements, saying respondent misrepresented, and they said, no, we don't want to get involved. So my thinking is that if we have to do a formal hearing or something like that, they're going to parade these folks up here and they're going to say, oh, I'm fine, because if they didn't want to sign a written statement to our investigator, they're probably not going to want to come to court and testify that these folks misrepresented them or misinformed them.
We have a motion, right?
We
Okay,
have a motion to concur with council's recommendation by Ms. Jones.
second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
These next three cases are all regarding the same respondent. Case number 2014-01-5601 is a competitor complaint alleging that the respondent alarm company employed improper door-to-door sales practices where the salesman failed to identify themselves with the correct alarm company. The salesman allegedly advised the consumer that they are there to, quote, upgrade their system, and in fact changed the system over to the respondent company. The respondent has previously received a letter of warning for this conduct. The respondent's business cards have the monitoring company's name and logo prominently displayed, but does not have the respondent's name except as an email address. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of Tennessee Code Annotated 62-32-319D.
For the record, this is not the same company from the previous complaint.
No,
This is
ma'am.
another company.
That's
Okay.
correct.
Were they using the same monitoring company before and after? Is that why we're saying they had the monitoring company's name and logo? So that it appeared they were the same?
Sure, I'm
I didn't
following
follow
your
why.
question.
Well, where it says the business cards only had the monitoring company's name and logo, why wouldn't that have clued them in it was something different? Was the monitoring company the same? They were just a different dealer trying to switch them from? It seems like there was some, we're trying to say there was some, they were misleading them with only putting the monitoring company's name.
Well, you're not permitted to operate as a alarm company by using any name other than what you're licensed on your certificate. And it appeared in this case that they were actually using a different name.
I don't think there was anything on their documentation or business cards to show that they were
That's a separate
a separate company.
violation. Okay.
Make a motion that we concur with council.
Second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 20140156611 is a consumer complaint that alleges that the respondent alarm company employed improper door-to-door sales practices where the salesman failed to identify themselves with the correct alarm company. The salesman allegedly advises the consumer he was there to, quote, upgrade her security system, and in fact changed the system over to the respondent company. The respondent has previously received a letter of warning for this conduct. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in the security alarm business under a name other than the certification name that appears on the certificate issued by the board in violation of Tennessee Code Annotated Section 62-32-316E, as well as engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 62-32-319D.
Is the person that's going door to door making these requests to upgrade, is this a registered employee? And is this respondent company licensed to do business in Tennessee?
It would have to be, or we'd be filing them for
what
uncertified
I'm-
activity.
They are.
I know, but that's what I'm wondering. I mean, do they represent a licensed company in Tennessee, and is this person a registered employee in these cases?
They are licensed. They're a licensed company.
And that's a registered employee that's doing this door-to-door sales?
I'm not sure if we know which exact registered employee it is. Do you have the? But I mean, it's basically the same. It's the same respondent as the previous complaint,
All three of these, or is it
Yes,
three?
sir.
Wrong.
and it's similar to other complaints that we've had against them before, where we sent them a letter of warning, and apparently they just didn't change their methods.
Well, do you get the feel this is one door-to-door salesman, or is this a team of people they've got out working?
Most likely a team.
Okay. Okay, do we have a motion on this 6B? No, we don't. We need,
Previous complaint that they approved, you talk about the business card with the wrong name on it, but there's no reference to the 6232-316E.
That would apply in that one as well. Yeah. I just cited 319D, but 316E would also apply.
So on 6A, let the record reflect that you're also going to insert TCA 6232-316E as part of the reference
Yes,
also?
ma'am.
Okay.
I would make a motion that we concur with council's recommendation on 6B.
Second.
Okay, we have a motion, Mr. Cockcroft, and a second by Ms. Jones to concur with our council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-01-5992 is a consumer complaint that alleges that the respondent alarm company employed improper door-to-door sales practices when the salesman failed to identify himself with correct alarm company. The consumer did not allow the salesman inside her home and said he became agitated when she refused to do so. The consumer said that the salesman wore a polo-style shirt that displayed the logo of the monitoring company, but not the respondent alarm company. The respondent has previously received a letter of warning for this conduct. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $1,000 for engaging in the security alarm business under a name other than the certification name that appears on the certificate issued by the board in violation of TCA 6232-316E.
The name on, we're going strictly by the name on the shirt, right, is all?
I think the name on the shirt was the logo of the same monitoring company as that was on the business card in the previous complaint.
My only concern would be is if we're this is towards the monitoring company, and I mean there's could be a lot of shirts floating around. If we're basing this entirely on somebody wearing a shirt versus
This is going to the alarm company that's going door to door, not to the monitoring.
okay, because so it is the dealer's logo or name or
This one is the respondent alarm company.
The alarm company's licensed, but they weren't wearing their name on their shirt. They was wearing XYZ monitoring station on their shirt. And
how do we know
using
who it was? Though?
tried to force his way into their home.
Thinking that they sent us.
Well, and then the monitoring company also sends us correspondence. So they admit basically, yeah, that's our shirt and that's our affiliated dealer.
The dealer.
But again, they send the same letter that say we don't condone these type of practices. But as we've seen, I think over and over, they haven't done anything to remedy it. So I think, and as Ed pointed out, I mean, this is the third almost exact same complaint. I mean, it is the same complaint, basically from 3 different sources. So, I mean, I think that the board's within their rights to.
Make a motion, we concur with council.
We have a motion to concur with our council's recommendation in this matter. Do we have a second?
I'll second as far as moving it forward.
Okay. Second with discussion.
My only concern is that we're basing this entirely on the name on the shirt. If I'm reading it right, we don't know for sure who I just hate for us to be putting out a consent order
Well,
with it.
We're sending the civil
Based on-
penalty to the dealer, aren't we? That tried to
Yes,
force
ma'am.
his way in the door.
I just want to point out that I think that there's evidence in the file to suggest that the monitoring company, regardless of the name on the shirt or not, has
Allowing it to happen.
admitted that yes, that's our dealer, and we are aware of the situation. So we have more evidence than just the name on the shirt that we're going by. So
I felt comfortable with the first two. It sounded like we had a lot of information in the record. I know there's a lot of shirts float around. I've seen techs work for one company and wear another company's shirt. I would just hate for us to be basing it strictly on the name on a shirt.
But they shouldn't do that either. We would fine them for that too. If
Wear your
if you was wearing my
company's-
shirt and trying to sell an alarm, they'd fine me and you. Would you think that wouldn't be right, would it?
We don't have anything in there about uniforms or anything of that nature. I mean,
Yeah, you're supposed to display your license when you're on the job site.
but displaying your license versus wearing a shirt that's got a monitoring company's name on it.
Wouldn't have made it in my door, I can tell you that.
Well, it sounds like he didn't make it in the door, and I don't like this type of activity. I mean, I'd like to, I just want to know that we're putting it against the right person. It sounds like we don't even know for sure who the individual was. But
Was this company not licensed, the dealer?
I think that's the one, is it the same case that the dealer,
No, the dealer's licensed in this case.
But instead of wearing his name on his shirt, he was just wearing the monitoring station's name on his shirt.
and giving out cards that had the monitoring station's name on them?
Basically, that was giving him a license to act rude because he didn't have his name on his shirt. Therefore, you didn't really know he was with RST Company.
Okay, any more discussion? Okay. We have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with their council's recommendation in this matter. All in favor, voice by saying aye. Aye. All opposed? Okay.
Wait, he seconded it. You can't second it and then oppose it, can you?
Well, he seconded it.
Second it for
With
discussion.
discussion purposes.
Okay, excuse me.
That's okay. Okay, I think, are we ready for number 7? Is that
Yes, ma'am, I believe so.
Okay,
And this one is the same one as 6C, except this is against the monitoring company. First one was against the alarm company. This one is against the monitoring company. The same set of facts. And the consumer said that the salesman wore a polo-style shirt that displayed the logo of the monitoring company, but not the alarm company. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $1,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 63-32-319, and would also fall under operating under a different name in violation of TCA 62-32-316E. Did I confuse y'all on that one? Do I need to go back over it? Okay.
this is a different monitoring company than the earlier similar complaint that was before, like 4B and, was it 4A and B?
It's not the same as that series of cases.
I make a motion to concur with council.
have a second?
I just don't feel comfortable with, I don't think it's, as far as going back against the monitoring company with strictly based on a logo of the shirt.
I'm going to second the motion based on the fact that the monitoring company has previously been made aware that there are questionable practices involving their clothing or cards or whatever, and they've not taken corrective action. So we have a motion by Ms. Jones and a second by myself. All in favor, voice by saying aye. Aye. All opposed?
Opposed?
Okay. Number 8A.
Case number 2014-01-7461 is a consumer complaint that alleges that the respondent alarm company, buying through a door-to-door salesman, employed misleading information to sell complainant a new contract. The complainant alleges that the salesman told him he was there to, quote, update his present system by changing batteries and keypad at no cost, end quote. He was then switched to the respondent alarm company. The respondent did not reply to inquiries from the board office. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,100. This figure represents $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D, plus $100 for failing to respond to a complaint in violation of Rule 0090-01-.14.
Do we have a motion from the board in this matter?
I intend to concur with council because of their practices.
So you're making a motion? Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second?
Second.
Okay, we have a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
Case number 2014-01-8491 is a consumer complaint which alleges that the respondent alarm company, buying through a door-to-door salesman, employed misleading information to sell complainant a new contract. The complainant alleges that the salesman told her current alarm security company was being taken over by the respondent. The complainant's alarm system was then switched over to the respondent's system. The respondent states that after the contract was signed and before installation of the system, a, quote, welcome call is placed to the consumer. These telephone calls are recorded, and respondent offered to provide the board with a recording of the call, wherein it was explained to the complainant that respondent was not associated with her previous provider. Additionally, after being contacted by the complainant's attorney, the respondent allowed the complainant to cancel her contract and refunded her money. The recommendation is to close for lack of probable cause for discipline, as this appears to be a contract dispute best resolved in civil court.
But didn't you still have false and misleading statements made by the door-to-door salesman about one company being bought out by a second one?
Yeah, they happened to catch it and they let them out of it, but it seems like there's still.
Still, but,
It could very well,
because, I mean, this very similarly fits
It's the
previous
same company.
facts and circumstances that we've had that, you know, okay, they got caught, so they let her out of her contract because there was an attorney involved, but, you know, initially it was by a door-to-door salesman that falsely stated your company is being bought out when in fact it wasn't. So to me, you've got fraudulent and dishonest statements made by this salesperson.
this was one that I went back and forth over. I mean,
I I think just for consistency's sake, with the fact we've got this presented to us, they did false give her fraud or make fraudulent statements and dishonest statements to her about her existing company. So I would, my thinking is that we should do the same in this case as what we've done along the lines in the previous cases for the civil penalty on the
I
formal
would tend to
hearing.
agree.
All the others where they say, I'm here to upgrade your system.
Right.
This is the same as this is the same as.
6A is basically,
You mean 8 is where it,
no, I
8B
mean,
or whatever?
no,
case is
6A, I mean, the
6A.
6A facts and circumstances are very similar to what we're looking at in the current case, and in that particular one that we voted, the recommendation was authorize formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D. And I was using that as a basis for this particular one if we set a penalty for it, a civil penalty.
And it is against the installer, the dealer, whatever, is who we're,
The
'cause
alarm
it sounds like,
From the
it
alarm
sounds like
company.
this might have gotten caught when it was going through quality assurance or something, but it's not like a dealer program.
It's still their representatives out there making false and fraudulent statements to
Right.
the consumer.
I agree with you. I just want to make sure we're aiming it at the right person.
Yeah, but we're aiming, I mean, in this case, it's at the alarm systems contractor, correct? There's no monitoring company or anything else, we're,
Alarm system. But they, I think if they did have a wrongdoer out here, I mean, if you'd allow me to play the devil's advocate for just a minute, I'm certainly, whatever y'all want to do is fine with me. But if they did have a bad actor out here, they did have that person making the phone call and explaining it to the consumer that hopefully would remedy what that bad actor did.
do we know if that's happened?
Well, they did in the welcome call, they explained that, we're not taking over. Let's see exactly what they said.
Consumer
Plaintiff
still filed the complaint
was
because
not
they felt like
associated.
it was misleading, so.
Yeah, I just wanted to make sure I had to explain that
Even if
to
they
them.
were let out of the contract, they probably felt damaged from the standpoint they had to get put back. They weren't whole if they were just being let out of the contract.
Not only that, they had to get an attorney involved in it too.
Well, I would make a motion that we authorize a formal and send a consent order with a civil penalty in the amount of $1,000 or $2,100, $2,000.
Say it was
But So he
2,000.
can make sure the language is 2,000 for
For
engagement.
engaging in for $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D.
I'll second.
Okay, we have a motion by Mr. Cockcroft and a second by Ms. Jones to authorize a formal and a consent order with a civil penalty in the amount of $2,000, all in violation of TCA 6232-319D. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. Number 9.
Case number 2014-01827. The complaint alleges that the respondent company was engaged in unlicensed activity by installing closed circuit or IP cameras in local hospitals. The respondent complains that they are a licensed electrical, mechanical, or HVAC contractor who derive less than 50% of their gross annual income from the direct sales, monitoring, installation, or maintenance of alarm systems and are therefore exempt from the Tennessee Alarm Contractors Licensing Act by TCA 6232-305 subsection 7, and they submitted proof of their qualifications back in July of 2009. However, their general contractor's license expired on January the 31st of 2013 and was not renewed until June the 1st of 2013. So they are instructed when they get their letter telling them that they get an exemption, that their exemption expires when their general contractor's license expires. And they let theirs expire, so they're going to need to re-qualify or reapply for that exemption again. And so our recommendation was to close with a letter of instruction to the respondents that they need to reapply for their alarm contractor's exemption.
Do we know if they have done other installs beside this particular one using this invalid exemption?
It was more than just one building. It was at least 2 buildings, but that's all that.
We wouldn't fine them for
so-
unlicensed activity during the time that their general contractor's license had expired?
They've lost their exemption.
Had they ever applied for the exemption? I know in the past, at one point, they didn't have to apply, right?
Well, they
Yeah, you
did,
have
and they
to
got it
apply.
in July of 2009, but
But it expired
subsequently,
when their contractor's
it
license
expired
expired.
when, right, so they
So
no
we
longer
run a
have that exemption.
cross-reference on our list, and if their electrical, mechanical, or HVAC license expires,
And they were previously
we
licensed
generally
alarm
leave them on
systems
the list for
contractor?
30 days, and if they hadn't renewed it, we take them off.
And they were previously licensed as a
Right.
alarm systems contractor, so they are,
And
Familiar
again, general
with the rules.
contractors cannot even file for the exclusion, so we probably need to use some word other than general, because they're not eligible to file.
okay. Yeah, because the language does change. It says licensed electrical, mechanical, or HVAC.
Didn't at one time, weren't they just excluded without having to file, but
We've
now they have
always
to
had a
file?
rule,
That they
the
have to
law
file?
just says they're excluded, then we have a rule that says they have to file for it and prove that they have that license. It's a little confusing. The law says they can be exempted.
And this was a 2014 case, is that correct, according to the case number? So it was definitely after the 6/30 of 2013.
After theirs.
Yeah, I
had
think I
expired.
agree. I think we have some unlicensed activity going on here.
Times however many buildings they did,
That's correct.
which is considered job sites.
What would y'all recommend from a
I was going to ask Mr. about a recommendation as far as unlicensed activity.
Well,
About what rule that is?
oh, what rule
Yeah,
it is?
and the penalty.
It's TCA 6232-304A. Very first one.
Board.
Is this their first offense?
As far as we know.
About
Motion that we amend
Well, we're going to make a motion on it.
8B, isn't it?
This is 9.
9. No, it's
Just
just
9.
9 at the bottom. Yeah.
Make a motion that we fine them $500 for, since their exclusion has run out. And it's 6232-304A. Authorize a formal into consent order with a civil penalty. I was just referencing the law,
Okay,
the
so
code.
Ms. Jones's motion is to authorize formal and send a consent order with a civil penalty in the amount of
$500.
$500 for violation of
Attention. May I have your
TCA.
attention, please? We had a false alarm in the building. We're investigating the issue. All clear. Please return to normal operation. Thank you.
Didn't know we had an alarm.
When one smoke goes off, they all
Probably
supposed
only
to go
sounded
off.
on the floor there,
Oh.
and the one above it and below it. So-
Okay, you made the motion.
6232-304A under prohibited activities. Ms. Jones made that
And
motion.
I'll second the motion.
And we have a second by Mr. Cockcroft. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries. That's correct.
Correct.
TNA case number 2014-02-1501. The complaint alleges that the respondent alarm monitoring company engaged in conduct that constitutes improper, fraudulent, or dishonest dealing by allowing the respondent alarm company, which is the next case, to use the monitoring company's name on its employees' ID cards and business cards. An examination of the business card demonstrates that the monitoring company's name is printed all the way across the top of the card, and the alarm company's logo, but not the name, is printed in the lower right-hand corner. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D.
And this is the alarm company.
The monitoring company.
The 10A is the monitoring company.
Yes, ma'am.
Okay.
Did we have a response from the company? Did they?
I'd say we probably did because there's no
They did respond.
violation.
They acknowledge the dealer or deny or?
They are wanting to remedy the situation through their attorneys, and they had some acknowledgments. They didn't make any omissions, but they said we can see how you all see it that way.
Same monitoring station.
It's not the same one that we've been talking about.
So this is a
previous.
different group of characters.
This is a different
Okay.
outfit. And they are wanting to work with us to improve the way their logo and names being used. But
Just give them some advice. Yes.
Okay. We have a motion.
I
on
make a
this.
motion to concur with council.
We have a motion by Ms. Jones to concur with her council's recommendation in this matter. Do we have a second? Second it. All in favor, voice by saying aye.
Aye.
Aye. All opposed?
Opposed.
And then 10B will be the alarm company? Okay.
yes, ma'am. Complaint arises from the same set of facts. The business card demonstrates that the monitoring company's name is printed all the way across the top, and they actually don't have their name on there except for their logo in the very corner. And So the recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $1,000 for engaging in the security alarm business under a name other than the certification name that appears on the certificate issued by the board in violation of TCA 6232-316E.
Well, their company certification or their QA number or nothing's on that card other than the monitoring station's name and their number and their,
The Tennessee license is on there
for the monitoring station
numbering.
or the dealer.
For the dealer. The dealer's licensing number is on there.
Otherwise, we would never have known who it
Who it
was
was.
because their logo is a DBA.
Why would the civil penalty be less for them than the monitoring company? I feel like the one that's actually doing the violation, the bigger violation is the company.
I mean, actually, you have violations of both of those. You can tack on the previous TCA 6232-319D as well, because I think that's consistent with what we've done on some of the previous ones. That is correct.
Correct.
Okay, I would make a motion that we authorize a formal and send a consent order with a civil penalty in the amount of $2,000 for engaging in security alarm business under a name other than, do I need to list this as 1,000 for each, or, so 1,000 for engaging in security alarm business under a name other than the certification name that appear on the certificate issued by the board and by 6232-316E, and an additional $1,000, and that one is for, what's the statute on that one, or the rule?
Above it.
So it's
19D.
$1,000 for engaging in conduct that constitutes improper, fraudulent, or dishonest dealing in violation of TCA 6232-319D.
I'll second.
Okay, we have a motion and a second for $1,000 in violation of 6232-319D and $1,000 for violation of TCA 6232-316E. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 20140215511 was initiated when, during the course of the investigation of a previous complaint, a representative of the respondent attempted to sell the investigator, who had not identified herself as such, a new home alarm system over the telephone. The representative was located outside the state and did not have a registration to engage in the business of any alarm system contractor in the state of Tennessee. The representative assured the investigator that respondent had, quote, technicians available in Tennessee from their Nashville, Tennessee location, end quote. But the respondent had no registered employees in the state of Tennessee. And so the recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $500 for engaging in the business of alarm systems contractor without certification in violation of TCA 6232-304A.
So did they respond to your request, or, I mean, what was the explanation when they found out what they had done?
We heard, I think it was, I don't know if it was the last meeting, or we heard a similar complaint where somebody had gotten a telemarketing call is this related to that? Is that what they were?
Telemarketers are exempt, just,
They're exempt, but they've got to be
Well, I
working
think this
for
was a
a.
call made by our investigator
Now, our
on a
investigator
case, and they were
called this
solicited,
company in an investigation.
and without knowing that this was a Tennessee state investigator, this unlicensed person solicited to sell this person an alarm system. I think, isn't that pretty much, yeah.
One of the problems was said, we've got people in Tennessee that can, because the investigator said, well, what if I have a problem? You're out of state. What if I have a problem with my system? And the person on the other end of the phone said, well, we've got people in Tennessee. Our company has people in Tennessee, in Nashville, that can come and take care of your system. But they didn't have any kind of license. So this wasn't sent for a response, so they didn't actually respond to this.
Someone file, there was a complaint filed, so that's how the investigators started this
I
complaint.
believe it'd be considered a board complaint, because in the course of a previous complaint, and I don't have the facts before me of what the previous complaint was about,
It was official business, in other words.
but the investigator called this person, and it,
It says during the investigation of a previous complaint is
That's
how
why
it
I
was
was confused.
generated.
I was just wondering if it was related to that other one that was telemarketing, if they were calling back about that or something. At that time, we didn't have anything further to go on. I think we closed, but the telemarketers don't have to be licensed, but they had to be working for a licensed company. So but we didn't have anything to go further on that case. I just wondered if it was related to that or not, if we had actually gotten something to go on, is what it sounds like.
Well, that is, we're still on the same one. That's always been a question I did not know the answer to. You have a Tennessee license for your company, but you don't have any registered employees in Tennessee. How do you do business in Tennessee?
Well, we got,
We got
again,
quite a few companies, so we always question how you getting these contracts, how you doing this work? Of course, if you sub it out, you gotta give it to another licensed company, I understand it, but that's always a question I've asked.
I agree.
But it's
They get-
reasonable. I mean, if you have no employees, how can you come,
How can you conduct business without,
right?
or how
I've
can you
asked,
monitor
I ask
alarms?
every one of them that call me, that of course they don't know the number.
they don't know the number.
And I
And they
I
don't
say, who's
really
coming to
know.
my house? I'll tell them, yeah, set me up an appointment. And they'll say, okay, so-and-so will call you, and I'll say, who's so-and-so? They'll say, well, you'll find out when they call you. I said, no, I want to know now. Click. They won't tell you.
Well, sometimes if you ask them what company they represent, it's some marketing company that isn't anything.
Right.
I do think there's companies that they do telemarketing, they market, and then they try to push the lead off to somebody. And I don't know where that really falls in this. It seems like that's kind of a gray area, that they might be, if all they're doing is telemarketing, but, and if they're
Again,
saying
Yeah, but I
They-
don't think a telemarketing is the case.
on this one,
No, I mean, they called a company pursuant to a previous investigation, so, that tells me right there, the investigator didn't call a telemarketer, they called either a monitoring or an alarm company to try to ascertain information pertaining to one of these previous cases. Is that, okay? I think telemarketing's not relevant in this. I think it was just they got caught not knowing they were talking to a state investigator trying to sell an alarm system when they're not licensed in Tennessee.
I make a motion to concur with council.
Okay, we have a motion by Ms. Jones to concur with our council's recommendation. Do we have a second?
second.
And we have a second. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
It's number 2014-024391. The complaint was established against the respondent alarm company when the board office received registration applications for 4 employees, which were filed well after the 30 days of the employee's employment date. However, it was determined that these employees were telemarketers, exempt from the registration requirements by Rule 0090-01.03, subsection 8, and had not yet begun their new duties, which require registration. The registration applications are still pending at this time. and the recommendation is to close.
I would make a motion that we concur with council and close at this time.
A second.
Okay, we have a motion by Mr. Cockcroft and a second by Ms. Jones to concur with their council's recommendation. All in favor, voice by saying aye.
Aye.
All opposed, the motion carries.
Case number 20140-24301 was established when the respondent was established against the respondent alarm company when the board office received a termination transfer form for an employee who had never been registered with the board. The employee's employment date was listed as March 18th, 2013, and the termination date was listed as August 13th, 2014. The complaint also alleges failure to register an alarm employee. The recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $800 for failing to register employees within 30 days in violation of TCA 6232 312 subsection C. This amount represents 16 months times $50 per month.
They have an explanation for this.
It was for, what they were submitting it for was termination. It wasn't for transfer or.
Yeah, but it was for an employee that had never been registered.
Right. At first I was thinking it was a transfer form, and I was like, well, how would they think they're transferring them without the number? But
Unless
it's-
it was a separate DQA
right.
that
I
did
know
the
it's the same form,
termination
so.
than who was running it back in 2013.
That's why I asked Mr. Scudder if they, if that could be the case, what was their explanation for
Yeah,
why
the employee
they
could have been there.
terminated a non-registered employee?
They state the employee was initially hired for non-alarm monitoring related position, and then in July of 2014, the employee was promoted to a sales position where she would be traveling occasionally to Tennessee, and that their registration paperwork was started, but then the position did not, they said that the mail was mailed, but it came back to them, and by that time, the employee had been terminated. So at first
Based
they-
on their explanation, they were within the 90 days of when they went into the registered position. But
So they didn't actually move that person into a registered position until July.
July, and then they said they tried to mail on August the 11th, and that the paperwork was later returned because the post office mistakenly thought there wasn't enough postage. Our
on the
company
initial
receives-
application,
So if I understand this correctly, once they moved her into a registered employee position, they did attempt to send the employee registration application in, but the post office returned it for lack of postage. But then, within the next 30 days, she quit, so. Yeah, but when was the application date versus the date when she quit? I think that's,
Her date in 2013 and her termination date in 2014.
So they mistakenly put her hire date in a registered position as the wrong date. They put it as her original hire. Right.
Again, all we have is their explanation to go by.
yeah.
and it's easy to, I mean, we talk about the date in the registered position, but the form doesn't say, it does say date of employment or something. I know that's. Does it say that now?
Yes.
I didn't think it said, okay.
Unless you got an old one, the old applications years ago did not
Said
say
date
that.
employed.
So we tried to clarify.
Well, these
So
have been
next
in
time
place
we're gonna
since
say in
09.
Tennessee. We're gonna,
Yeah, we're
I
gonna
mean,
add
the date-
employed in a Tennessee registered position,
Yeah.
but these have been on the forms we're using now were revised in 2009.
What did they say in their explanation that she was doing in that unregistered position? What were her duties then?
Let's see. She was initially hired for a non-alarm monitoring related position. And that's all they really say.
He
Maybe,
was out of state, or the,
Is this a
Was that-
central station?
I may have misread that. It may have been properly read, non-alarm monitoring related position.
So it's a central station. It's a.
Yeah, it is a monitoring station.
Stations can limit what accounts you.
by
you-
state or what, to give it,
Some can, some can't, depends on the equipment, but.
different amount. 800 seems like it might be a bit much in this particular.
They
August.
said July when she started in the position, not March.
Yeah, but they said July of 2014.
That's what I was saying, you know, if they're telling the truth about her duties, she really wasn't, you know, she wasn't, they weren't in
They
violation,
never did turn in the application.
but she quit.
Yeah, but you still have to turn in an application for a year.
They
I
still
know,
should
but
have
if
had
she
her
was in a
application.
non-registered employee position,
Her application should have been here between July and August,
yeah, but they said it was returned for like a postage.
because the post office didn't think there was
Right.
enough
And,
postage.
and I'm sorry, but if they turned in a termination notice date and her termination date is August 13th of 2014, and they didn't hire her till July, I don't know that they have time to even mail the application and wait to get it back in the mail. It just.
Is this the first offense for this company? I guess is what we're saying. Maybe the fee's too high. Maybe a
Well, do a
letter,
letter
you
of
could do a
warning.
letter of warning, or you can do it the first time.
I don't really know.
I think I would be comfortable passing this to December with the request that Mr. Scudder contact this company and have them specify, specifically what her duties were. Non-alarm monitoring doesn't tell me anything. I mean, that doesn't mean she didn't have access to account information in a monitoring office or whatever. I would like to know specifically from March of 2013 until July of 2014, what were her duties that exempted her from having to be registered?
It would be hard for an employee to not have something to do with,
Well, I know, but I think,
we'll wait for an explanation.
right. But can we just pass this one to December and,
So do we need a motion for that, or?
yeah, you were, okay.
So I would make a motion that we
Represent this.
represent this at the next board meeting after you, and
Ask for additional information.
with it, if you could request additional information from the respondent.
A second.
Okay, we have a motion and a second to reschedule this presentment until the board meeting in December of 2014. All in favor, voice by saying aye.
Aye.
All opposed, motion carries.
Finally, we have a case that's for representment. This case was originally presented to the board on March 13th, 2014. It says 2004 in your notes. I'm sorry, that should be 2014. The complaint was established as a result of an unsatisfactory compliance inspection wherein it was determined that the respondent had been monitoring accounts for this Tennessee company after their license expired in 2008. At the March meeting, the board authorized a civil penalty in the amount of $500 per account monitored once that number had been ascertained through investigation. $1,000 per account monitoring once that number was ascertained through further investigation. However, the investigation revealed that the current owners had not purchased the respondent monitoring company until April of 2012. So they were being fined for something before they had even bought an interest in the company. And we also found that the number was going to be basically unworkable in the trying to do it per account. So the recommendation is to authorize a formal and send a consent order with a civil penalty in the amount of $28,750. This represents $11,500 for engaging in the business of an alarm systems contractor without certification for 23 months, plus $17,250 for operating without a licensed DQA for 23 months, for $17,250. And those two figures together comes to a total of $28,750.
So they bought this company in April of 2012, but it wasn't until just recently that they were licensed or
They're in the
registered.
process of getting licensed. It's being held up because the complaint's open. The respondent here, and I can offer some insight on this because I was the one that presented it originally. Originally, what we did not know was that this is a different management of this company. When they purchased in 2012, when I originally presented it, it looked like it was the same respondent, same management that had been fined previously by the board, and that's why we decided to go with 1,000 per account. I mean, sometimes you have to get their attention, but this definitely got their attention, and they submitted to us a timeline of when they purchased and what steps they were taking. They purchased a lot of companies in one big grab, basically, and they have compliance people. This is a monitoring station in Texas, and they were going through the changes and trying to, make sure that they were in compliance in all the states that they operate in, but they hadn't gotten to this point yet before they got this giant consent order, which this represents a significant reduction of the previously authorized of $500,000, which, I mean, the board isn't here to submit, what would be punitive damages or put anyone out of business. And from what I've seen, it looks like they are trying to get into compliance and are trying to get all the required licenses. And the company that they were monitoring accounts for is under the same management now. And they had been previously disciplined by the board, and there's a consent order outstanding on the local Tennessee company as well that I think they're not going to contest, from what I've heard from the attorney, in the amount of $16,000 or $16,800 to that company for allowing this unlicensed monitoring company. I mean, basically joint venturing with them to monitor accounts. So, Ed and I sat down and tried to work out something that's more reasonable, that isn't going to put them out of business and isn't going to amount to punitive damages.
So the company that license expired in 2008, they're out of the picture completely.
Yes, they sold their entire assets to this new management.
2012.
Right.
So the 4 years, give or take, that they operated illegally is just, it's a moot point. We're only dealing with the violations
Right.
since 2012.
You
Right.
could probably technically pursue the prior owners, but that's probably,
It's a moot
pointless
point.
at this point.
Yeah.
But
I understand what you've done. Do we have a motion in this matter?
know how many accounts it is? Was it based on the number of accounts couldn't be determined, or
Well,
was
if
this
we,
would have been so high based on that?
I mean, basically, it would amount to, even if we went, because obviously, when you're talking about $500 to $1,000 per account, they're going to want exact numbers. I think that the local owner of the Tennessee company affiliated with this monitoring company had stated to our investigator previously that he thought it was something like 500, so that's what we based the original penalty on. However, I've been in communications with their attorney, and I think he said it's more like 360. But even if you do, a first-time offense at 500 times 360 is going to amount to. I mean, I don't know if we're ever going to get.
But it's still not to get to the penalty based on the numbers. I was more wanting to know. It's not like we're talking about 10 accounts or 20
Oh, no.
accounts.
I mean, it's a
fairly
significant
number.
amount, and
So-
they have, I mean, they've admitted that, yeah, we understand the problem, but at the same time, it's not the board's function to to authorize penalties that would become punitive and probably discourage the company from doing business here.
Basically, what y'all are recommending is just for the period of time, not for the number of monitoring accounts they had, but for the period of time that they were operating illegally, which is proven and easily documented versus this other magical number.
Right.
And it's not going to put them out of business either.
This is a reduction, obviously, based on, because I think this was before I was here. We're talking about that's basically
Pretty significant.
Significant.
500,000 down to 28,000.
Was there actually a consent order issued for that much for the?
Yes.
Okay.
But I mean, I think sometimes, and I don't know, but sometimes I think penalties are issued in an effort to, hit them with the big hammer and say, pay attention, because we thought, based on previous information that we had, that this had been a company that we had penalized before, a pretty significant, I mean, I don't know, it wasn't close to that, but they had been put on notice that they needed to be licensed to do business here, and it looked like the same company, and it looked like they had been doing it continuously since the last time they paid a fine. So I think the board took a pretty hard stance against that because it looked like they were just ignoring us. But
Only to find
now,
out it's not the same company.
now that we
It's-
find out it's not the same company and that they are trying to get into compliance, and based on that unwieldy number, I think that this represents a more reasonable,
And obviously, they have a chance to, I guess, because they can come to the formal hearing versus the consent order. But you get a feel that they want to move forward with a consent order and get licensed. And
I mean,
they-
yeah, I've met with their attorney a couple of times, or spoken to him on the phone, met with him once, and I mean, they want to move forward and pay. They understand if they have to pay something, but I mean, there's just, and I can understand his position that there's just no way that they can pay $500,000, and they're not going to agree to that. And I don't even think.
Plus, that's for a period exceeding how long they've been responsible for it as well, too.
Right. And I mean,
So-
it was just one of those things I explained to him. I mean, when you look at just the numbers and what was authorized, it came out. But we authorized that prior to knowing that they had 500 accounts, so.
That explanation, do we have a motion on this matter?
I'm going to go with the recommendation to council, because if they're trying to comply and you've been talking to their lawyer, even if this doesn't get done, there will be a resolution soon with something. So if we keep going, it'll finally get to something instead of just giving up.
I think their license is ready to issue.
As soon as we finish the complaint.
Okay.
It's still a very significant penalty, but I feel like if they want to move forward, I think that's,
It was bigger.
well, I didn't know if the motion was finished. Or did you?
Yes, I'm
Yes,
done.
second.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to concur with council's recommendation in this matter. All in favor, voice by saying aye.
Aye.
All opposed? I hesitate because I
Just
want to
call
call
him
him Scott Croft, and then I just draw a complete blank because I think that's not it. I think I'm just going to start calling him Mr. Scott because that's what I want to call him anyway. But anyway, the motion carries. And I think that concludes the legal report. Do you gentlemen have anything else to bring before the board today?
Patience.
Well, thank
Thank
you.
you.
You did an excellent job.
Yeah, don't take it wrong that we may do something different here or there, that we're learning. At least I'm learning as we go too, so.
Okay. Do y'all want to move into the administrative reporting? Okay.
5-minute break.
That's fine with me. We can
5-minute
stretch.
break then, that'll be fine.
We're going to call back to order this Tennessee Alarm Systems Contractors Board meeting, Thursday, October the 16th, 2014. Next on our agenda are the administrative reports by Ms. Best.
Yes, thank you. This agenda is a little different from the one that you're gonna see up there. We're gonna do Exhibit B, C, D, and E. So Exhibit B is your open complaint report. As soon as I can get. This report has a total of 48, but you've heard 14 of them this morning, so it brings down to 34. And I was just speaking to Mr. Scudders that we will need to look at the ones that are pushing close to 180 days for our board meeting on December the 11th to make sure we get as many as we can heard. Appreciate having the board meeting this afternoon. Well, yeah, it is afternoon, so we can get these off the schedule. That takes care of that one. Now we'll go to the disciplinary action report, or you just have it for September. I believe it's $18,700 for the Alarm Systems Contractors Board. 1,800 civil penalty for the termination, 700 civil penalty for employee termination. And then we, of course, do have our other professions on there as well. And if you would turn over to the next sheet, you'll see private protective services. We have been moving on that. That's Ed's program as well. And you'll see civil penalties for notification of not being notified of an arrest. You'll see the ones that we've had the formal hearings on, or the ones that we are doing revocations on due to different types of arrest. We are in the process of working with the Department of Safety on a lot of that. Any questions, of course, stop me. The monthly report is for September 2, and I believe this is the one that gets mailed to you. You didn't email it this time?
I did.
Okay, email it. Okay, there's only, of all our programs, the only one that I have is the alarm board. Vivian Hickson term is going to expire on December 31st of this year. The rest of it is just the complaint reports for the other programs and the applications that have taken in, how many's been denied for various reasons.
Can I say something on that? The report I sent you guys, when we got the director's reports this month, they had come up with a new way to calculate, and it had doubled, and then sometimes there were discrepancies, so I didn't include the number of applications received or the number of renewals that were due. I'll try to, they've gone back and redone those reports with the right, we're still not sure they're right, but next month's report will be more comprehensive. So.
We didn't have any legislative contact. Well, we did, but not for the month of September. I'm not going to do that one. Do you want to put the agenda back up there? Because in our agenda different, yeah.
No, it's not.
That's not, well, I don't have budget update.
Oh, this is the old
That's the old agenda.
Yeah, we don't
Well,
have
hold
a
on just a
J or-
second on that then. We don't have the E, I don't have any legislative update for you right now. We don't have any. We will be going to be back into session, so I'm sure we will. And then F is the budget update. I'm supposed to give you an update on that every board meeting, but I'm gonna hold off on that, because at our December the 11th meeting, we will have a representative from the Commissioner's office to go over your budget with you, because they'll have the final totals
Does
in.
everybody have a printed agenda? Okay.
Ours
Like that,
stops.
though.
Our
But that's the old one, she had just happened
Right.
copy. Yeah, the other one, yeah. All right, then, of course, it just went down from D to E for the alarm employee application review. Are these on the web, on the iPads too?
The employees are.
All right, we'll go to Exhibit E1, if you find that on your iPad. This individual did disclose an arrest. Drug paraphernalia and possession of scheduled one with intent. Like I say, they did disclose it. Has provided your court documents. Has provided a written explanation. There's no C number on that letter, but the letter from the company does have the qualifying agents and company number on it. So I'll give you a few minutes to look that one over.
Were there things missing? I mean, was there something that wasn't reported? It almost sounds like the applicants.
No, if you look at the first, no, he did, he disclosed it, but I brought it to you because it was a Schedule 1 with intent.
Does it look, that's what I was, it looked like they were both disclosed.
Yeah, they're disclosed.
And then I thought his response was almost saying that he didn't think he had to report it, but he did report it.
Right, he
Denied
did.
originally material misstatement because he checked
did.
no on his application last time.
Oh, okay.
Once they're denied him, they have to reapply and just close it and provide an explanation. And we hear that a lot because when they go to court, they're told, well, you don't have to worry, this won't appear on your record. They're not told that if you don't come back in within the specified time frame to apply for expungement, it doesn't come off your record. So. All he was convicted of was possession, but it's been less than 10 years. So.
Church center in that town. He says he's. That's what I was asking.
They have 300 or 400 employees.
I recommend that we grant him his application for a registered employee. Motion based on the time that's passed and the position that he's wanting to do.
We have a motion by Ms. Jones to grant this applicant's employee registration. Do we have a second?
I've got one question. There's a new, we heard something about a new law where people can go, can't they, and once that presented, I mean, at some point in time, would we ever recommend that these people go through that process?
Expunged.
Well, it wasn't, it's that they can,
Now, ask for a restoration of rights.
right, and
That's
maybe this
for
says,
felony.
okay,
That's
and this
for-
is not,
No, those are for
We have
felonies
that one today?
No, we didn't bring it because we never got the explanation.
Okay. Yeah, so they can ask for restoration of rights, but for the one, they have to ask for the right to carry a weapon, the right to vote, and the right to hold a political office. That gives you back all your God-given rights, as you want to
So
say.
they've got a law now for a do-over.
No, they've got a law now that
It's
says you
not-
can,
Basically.
when you go back, if you're somebody who had a felony conviction,
You're rendered infamous
yeah,
on some crimes. You can't
Never.
get a gun
you can't
or
vote.
license or vote. And usually, depending on when you were convicted as to what you can get expunged.
It's not just an automatic thing either, because I know Bureau of ATF used to have to do investigations for people wanting to have rights restoration, and it was an in-depth investigation on interviews and so forth that had to be completed. It wasn't just an automatic, like a appeals hearing or anything, but this
Scott,
doesn't even,
this
doesn't
wouldn't apply in this case, but I was just curious, because
Yeah.
if we would start pushing people in that direction, because it does protect the company a little better, and it might, liability-wise, might be better for the board and the companies if
Very
they,
costly.
okay.
Well,
I
let
will-
me explain that just a little bit to you. We do sit down and take a look at these records. I mean, that's what we have to do. Like I said, this gentleman here did not tell the truth in the first application. So we ended up, Beth and I, whoever else in the office usually ends up talking to these individuals, and we do tell them, listen, this might be expungible, you need to go take this off, and let me know if it's taken off, give me a copy of the expungement if you've got one, we'll send it to the TV. We do work with these individuals, try to help them with these records
Yeah.
to a certain point.
I mean,
If it's
there are
something we see,
cases,
we know they can take care of.
there are cases where the case actually was expunged, but it just never got turned in by whatever agency it was. And then they'll send Cody or I want a copy of an actual signed expungement order. We send it to the TBI, and then we run a new report. So,
We try to work with them and try to, it's very difficult when you deal with the volume that we deal with of criminal records. But when we do have them on their telephone or we're talking to the QA, we tell them that's something they need to do. They need to see if it can be expunged. And if they've paid a lot of money for an attorney to take care of this, they need to go back to that attorney and say, there's something wrong here. So yes, sir, we do try.
Well, I'll second the motion to approve.
Okay, we have a motion by Ms. Jones, a second by Mr. Cockcroft to grant this person's registered employee application. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, we'll take a look at Exhibit E2. This individual did disclose, did have guilty of a DUI and guilty of a misdemeanor assault. You will see a written explanation from the individual along with the court documents and a letter from the company. I don't see a number on the letter from the company. That should be the last thing that's in the packet.
Don't see what, Kay?
Don't see a C number.
Okay.
if you'll notice, his application was also previously denied. This, I mean, what's this gentleman's title that signed this letter?
Johnny York?
He's their DQA.
It says for Safe Streets USA LLC in the state of Tennessee in his letter.
They have a license here, but they don't have an office here. They have an alarm contractor certification.
Okay.
But they don't have an office here that I'm aware of. In Bristol or anywhere.
Or like an office that's not open to the public that has to be
Right,
licensed.
somewhere where they can pick up equipment and,
Warehouse or something.
yeah.
The old rule, or was there an old rule back in 90 that said you had to have a storefront and a street address and all that?
You have to have a physical office address. There was a rule that
And
the
if you
QA
change
had
that
to
address-
reside within 60 miles of that, but
Yeah.
that's not in place anymore.
But maybe it's just if you change that address, you had to notify them. Is that still?
Yeah,
As long as they're not selling or open to the public, they don't have to
Right.
have the license and.
right. I mean, some of them even get signs to put up that say so-and-so training facility if it's in. No outward sign to the public that you could go in there and buy an alarm system.
I would make a motion to approve his application.
A second.
Okay, we have a motion by Mr. Cockcroft and a second by Ms. Jones to approve this applicant's employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, your next one is actually Exhibit E4. E3 has been removed. After further review, it was determined we didn't need to bring it for the board. This one here might be just a little bit more extensive. You'll see what he disclosed. Best I was able to determine, he's guilty of trespassing and shoplifting. You do have a written explanation, and then you have a character reference, which is the last one. Of court documents that he sent in with it. Letter from the qualifying agent.
reading every line by line, is a lot of this just,
It's just the
Payments
court,
and-
it's the document from the court
You
on
look at
every
the
action.
synopsis on the second page.
Yeah, it says charge one, it says guilty plea, 1998. You pled guilty.
I was just trying to find.
Worksheet that I do before I put it together usually gives you, especially with records like that, I've got them in order by date and what date they were convicted, so.
So 98 and 99 is all I find on him.
The last charge he had was in 2000.
A lot of stuff in 98, 99, 2000.
Uh-huh.
Applying for a technician's or job or a dispatch.
You know, we can't
Yeah,
differentiate between
registered
that.
employee.
He's
right
actually
now.
a field representative for an out-of-state company that. Sure.
So if I read this right, he's actually 38 years old now. It says 32, 35, but it's got 2011.
34 when he applied in April. So he's 35 now. He was born in. Wrote that letter in 2011. Other group.
Located out of state. The only reason I ask is that would it be a burden for him to come appear before the board or?
Like Salt Lake City, Utah.
That's what's confusing. I think some of that is old stuff though, isn't it? Is it?
Again, the list of stuff on page 2 is what he's been convicted of and what he disclosed.
He's attending a church in Utah.
And he is
Your
in
last
Utah.
letter is from
He's
Utah.
probably
6
part
days
of
before he wrote that letter. No, 6 days after he wrote that letter is when he went to their church on the 4th. 7 days, I can't count.
I feel like this has been a long time for his age and.
They didn't even write a letter for him.
You know, it's on the application. We
Right.
don't call them and ask for it anymore.
I
I
know.
do every now and then. If they provide a written explanation, whether there's a letter from the QA or not, we're gonna put it on the agenda. It's just,
Yeah, but if I'm not mistaken, the QA has signed the application, so he
the
should see
QA has
what's
to
on there.
sign the application, so.
So even his letter was written some years ago to somebody
Yes.
else. It
Yeah.
wasn't
Yeah.
about this
Somebody else
instance.
begging. I'm gonna make a motion to deny this applicant his registration based on bad moral character.
Second. Or you want the,
My motion, in a nutshell.
Okay, we have a motion by Ms. Jones and a second by Mr. Cockcroft to deny this application for registration. All in favor, voice by saying aye.
aye.
All opposed? I oppose it.
Okay, so, motion carried.
Still carries.
Motion carries, that's
Okay.
correct.
So what if this individual wants to appear and come in from Utah? We hear it again?
Generally, if they appeal it, we schedule them to appear.
I'm just saying, is that an option for him to come before the board, is what I'm asking? Okay.
They all have that option, don't they?
Yes, he just happens to be from Utah, that's gonna be a good little trip, but
He's probably here selling.
it might be, but. Okay, we'll go to Exhibit 5. Beth also has a workup on this one, and you look at that application, the sheet already said, the individual said it was petty theft with the question mark, so as far as I'm concerned, it didn't disclose anything. But we do show that there's theft where he pled guilty, from merchandise theft anyway. Probation violation. You do have a hard-to-read written explanation there. You do have the court document, and you do have a letter from the qualifying agent, and it does have the license number on it.
The two things were checked yes on, did the court dismiss charges and were the charges expunged? Were they both checked yes? Is that true?
I can tell. It don't look like nothing's been expunged.
Charges were dismissed either, according to him getting probation 11/29 and so forth. I would feel comfortable if we had him come in and to see the board, because he doesn't give us any details about this theft. I mean, it's completely avoided any particular details.
And the type of the being theft versus.
There's no details revolving. But according to this, he was convicted. He pled guilty in 2004, 16 hours of community service, $378 plus fine, 11 months, 29 days probation. There's, 2 probation violations on theft, so
So do we need a motion for that? Or?
Yes.
So, I'll make a motion to request, the applicant on E5 make a board appearance. Oh, qualifying agent preferably. At the next available.
December
their
11th
December
board meeting. All right.
Okay, we have a motion on Mr. Cockcroft to request this applicant to appear before the board at the December meeting with his QA. Do we have a second?
I second.
We have a motion and a second in this matter. All in favor, voice by saying aye.
Aye.
Aye. All opposed? The motion carries.
Okay, we'll go to exhibit E6.
Job of stating motions. but-
Okay, you need the experience.
This is a DWI now, an assault and a retail theft. You did disclose it, you have the written explanations, and you do have a court document. Company.
This person. Sales rep. Print from our screen. They're deleted.
here if she so desired, but
Okay.
And I'll second.
We have a motion by Mr. Cockcroft and a second by Ms. Jones to deny this employee application. All in favor, voice by saying aye.
Aye.
All opposed? Application is denied with the provision that this person can make an appearance in December if they so desire.
Okay, if they make the appearance in December, they don't have to make a new application, they just coming off this one here that you
Appeal and then
denied,
deny.
appealed.
Yeah.
Okay, good. So I want to make sure. Okay, well, just
I think that was the intent on,
all of them.
Right.
Okay.
That's what we normally do
Just
for
wanna make
board
sure.
denials, is if they appeal it, we schedule them up here.
Okay, the last one we have is E7. You show it here, it's another theft under $500, and this one was in 2012. It was disclosed. You do have a written explanation. We got a court document here, and we do have a letter from the qualifying agent.
Certification number.
don't some of these have them all printed on the back?
Pardon?
Don't some of these letters have them all printed on the back? Do y'all actually have an original letter?
Well, we'd have the original, yes.
I have the original right here.
I know some of those letterheads, they have so many licenses, they put them on the back, but that's not the case with them?
Not with this one. It's on there.
Oh, it
I
is?
was
That's
looking,
about
I'm,
Company ID
ID number,
1695.
I'm looking at the ADT logo, letterhead, all that from the girl or from the applicant, and it doesn't
letterhead.
have
She just
it.
used a piece of letterhead. The
Right,
qualifying
I
agent signed
realized.
it and put her license and the company license on there. Sometimes you see these ads on television.
So many
Little
licenses.
tiny print at the bottom with all the different license numbers. Station operator in Knoxville, alarm monitor customer support.
I think perhaps this one here might have, actually, if you looked at it, Vivian, you go over to the first page of the record, I think what they did, they put her on pretrial diversion and dismissed it. I didn't catch that when I looked at it.
That be up by now, as far as the diversion has a,
If
Yeah, if it was in 2012, what was it, April? Let me go back here. Yeah, March of 2012, be March of 2000.
it's
that
probably been
12?
expunged by now.
2012, 2013.
There's a date stamped on one of these things, August 12th of 14th of 14.
That's when we received the document in the
when
we-
office.
I don't see a problem. I would grant this applicant their registration. I make a motion.
second.
We have a motion and a second to grant this applicant's employee registration. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
All right, Madam Chair, that includes my portions.
We've got education report, course review.
We have one course that was submitted by Elite CEU out of Austin, Texas. It was a 4-hour. They actually marked it for employee training and continuing ed, but we don't approve employee training unless it's at least equivalent to level. So it's a continuing education course. I sent it out to Scott Cockcroft to review. They've requested 4 hours of credit.
It looked like, I mean, it had a lot of content. They just had it wasn't really the content of the course, but it had a lot of just the outline, I guess, all that it was going to cover, which it was 4 pages of just the outline. My only concern would be the time. Some of those classes seems like they really don't get anywhere near time-wise, but I don't know, do we have anything to gauge that by from the past, or?
We don't generally, we have had some, especially the online providers, that we've gone back after we've gotten complaints that it only took me 20 minutes to do that 4-hour course. To my knowledge, we have not gotten any complaints against Elite CEU. They provide alarm continuing ed and locksmith continuing ed.
But anyway, their 3-hour Module 1 life safety, it took me all afternoon Saturday and part of it was in depth. Some of their hour courses wasn't quite as long, but their life safety thing was very long and very good.
Well, it looked very in-depth as far as all that they're outlining. It just didn't have any content. It just strictly, it was what they were going to cover.
Right.
Some of the others I've looked at actually had PowerPoint and content.
Jade, some of the other online providers actually send us some of the course materials. Elite generally we only ask for a course outline or synopsis, and references if there are any that directly apply. Your rules are not real extensive on what they have to submit.
That's the only one we've got.
That's the only course we had, actually, until the next meeting, then if I get some more in, so.
I would make a motion, we approve Elite CEU. Do I have a course number, or?
It's 2011 NEC Wiring Methods and Materials.
I second.
Okay, we have a motion and a second to approve the Elite CEU NEC wiring methods and, what was the technology, what was the last word?
Wirings and
And
methods.
material.
Methods and materials for 4 hours of CEU. All in favor, voice by saying aye.
Aye.
All opposed? The motion carries.
I do not have any more courses or education.
Do we have any unfinished business? Any new business? Then this meeting's adjourned. Thank you all very much.